Question 1. System analysis indicates that an applicant seeking a concealed carry firearm permit, Porte de Arma de Fogo, in São Paulo, Brazil, has provided a statement of need that is vague and lacks specific examples of personal threats or vulnerabilities. Which of the following approaches best aligns with the regulatory framework for obtaining such a permit in Brazil? Option A. Recommend that the applicant obtain a psychological evaluation from a personal physician rather than a federally accredited professional, as this may expedite the process. Option B. Advise the applicant to gather specific evidence, such as police reports of threats, documented incidents of vulnerability, or expert assessments of personal risk, to substantiate their claim of a genuine need for self-defense, and ensure all other legally required documentation and evaluations are complete and accurate. Option C. Proceed with the application using the applicant's general statement of need, assuming that the desire for personal protection is sufficient justification under Brazilian law. Option D. Inform the applicant that a general desire for self-defense is the primary criterion and that detailed evidence of specific threats is not a mandatory component of the application in Brazil. Correct answer is B. Advise the applicant to gather specific evidence, such as police reports of threats, documented incidents of vulnerability, or expert assessments of personal risk, to substantiate their claim of a genuine need for self-defense, and ensure all other legally required documentation and evaluations are complete and accurate. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the complex legal and procedural requirements for obtaining a firearm permit in Brazil, specifically the Porte de Arma de Fogo. The challenge lies in accurately understanding and applying the specific criteria set forth by Brazilian law, which often involves demonstrating a genuine need for self-defense and meeting stringent psychological and technical proficiency standards. Misinterpreting or failing to meet these requirements can lead to denial of the permit, potential legal repercussions, and a failure to uphold the integrity of the firearm licensing process. Careful judgment is required to ensure all documentation is accurate, all prerequisites are met, and the applicant's situation genuinely aligns with the legal justifications for concealed carry. Correct approach analysis. The best professional approach involves meticulously gathering and presenting all legally mandated documentation and evidence to demonstrate a genuine, demonstrable need for self-defense, as required by Brazilian Federal Law No. 10. 826/2003 Estatuto do Desarmamento and its subsequent regulations. This includes, but is not limited to, proof of residency, a clean criminal record, psychological evaluation results from a federally accredited professional, proof of technical proficiency in firearm use, and a detailed justification for the need to carry a concealed firearm, often supported by evidence of specific threats or vulnerabilities. Adhering strictly to these requirements ensures compliance with the law and demonstrates the applicant's suitability and responsible intent. Incorrect approaches analysis. One incorrect approach is to submit an incomplete application with only basic personal information and a general statement of wanting to carry a firearm for personal protection without providing specific evidence of a demonstrable need or the required supporting documentation. This fails to meet the legal threshold established by Brazilian law, which demands a concrete justification beyond a mere desire for self-defense. Another incorrect approach is to rely solely on a personal belief that one is capable of handling a firearm, and to submit a psychological evaluation from an unaccredited professional or one that does not specifically address the criteria for firearm possession. Brazilian regulations mandate evaluations by professionals accredited by the federal police, and the content of these evaluations is strictly defined. A further incorrect approach is to attempt to expedite the process by submitting falsified or misleading information regarding criminal history or residency, or by omitting relevant details about past incidents. Such actions constitute fraud and are a direct violation of the legal and ethical standards governing firearm permits, leading to severe legal penalties and permanent disqualification. Professional reasoning. Professionals involved in assisting applicants for firearm permits in Brazil should adopt a systematic decision-making framework. This framework begins with a thorough understanding of the current Brazilian legislation, particularly Federal Law No. 10. 826/2003, and relevant decrees and administrative rules from the federal police. The next step is to conduct a comprehensive assessment of the applicant's eligibility based on these legal requirements, focusing on the necessity of a demonstrable need for self-defense and the fulfillment of all procedural prerequisites. Professionals must then guide the applicant in meticulously preparing and submitting all required documentation, ensuring its accuracy and completeness. Continuous communication with the applicant and adherence to ethical guidelines, emphasizing honesty and legal compliance, are paramount throughout the process. Question 2. Compliance review shows an applicant for a Porte de Arma de Fogo in Brazil is preparing their application. They have gathered personal identification and proof of residence, and have scheduled their psychological evaluation. However, they believe that simply passing the psychological test and having a clean criminal record should be sufficient to be granted the permit, without needing to provide extensive evidence of a specific, demonstrable threat to their personal safety. Which approach best aligns with the regulatory framework for obtaining a firearm permit in Brazil? Option A. Focus primarily on passing the psychological and technical aptitude tests, as these are the most significant hurdles, and assume that a clean criminal record and personal feelings of insecurity will be sufficient to satisfy the justa causa requirement. Option B. Thoroughly document and present a clear, demonstrable, and legally recognized justa causa, just cause for carrying a firearm, in addition to successfully completing all required evaluations and submitting all necessary documentation. Option C. Prioritize obtaining the necessary certifications and licenses from accredited institutions, believing that this demonstrates sufficient preparedness and implicitly justifies the need for a firearm. Option D. Submit all available documentation, including proof of residence and passing the psychological evaluation, and rely on the discretion of the issuing authority to determine if a genuine need exists, without proactively providing specific evidence. The correct answer is B. Thoroughly document and present a clear, demonstrable, and legally recognized justa causa, just cause, for carrying a firearm, in addition to successfully completing all required evaluations and submitting all necessary documentation. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to navigate the complex legal requirements for obtaining a firearm permit in Brazil, specifically the Porte de Arma de Fogo. The challenge lies in understanding and correctly applying the various criteria, including psychological evaluations, technical aptitude, and the demonstration of a genuine need, all while adhering to the specific regulations set forth by the Brazilian Federal Police and the Army. Misinterpreting or failing to meet any of these requirements can lead to the denial of the permit, or worse, legal repercussions if a firearm is acquired without proper authorization. Careful judgment is required to ensure all documentation is accurate, all evaluations are passed legitimately, and the stated need is justifiable under Brazilian law. Correct approach analysis. The best professional practice involves a thorough and honest self-assessment of eligibility against the explicit requirements of Brazilian law for a Porte de Arma de Fogo. This includes ensuring all necessary documentation is complete and accurate, such as proof of residence, clean criminal records, and the successful completion of psychological and technical aptitude tests administered by accredited professionals. Crucially, it requires demonstrating a legitimate and demonstrable need for carrying a firearm, as stipulated by the relevant legislation, which often involves proving a direct and present risk to personal safety that cannot be adequately mitigated by other means. This approach prioritizes full compliance with the legal framework, ensuring the applicant meets all objective criteria and can provide verifiable evidence of their suitability and necessity. Incorrect approaches analysis. One incorrect approach is to rely solely on anecdotal evidence or personal feelings of insecurity to justify the need for a firearm, without substantiating it with objective proof or meeting the specific legal thresholds for demonstrable risk. This fails to align with the requirement for a justa causa, just cause, as defined by Brazilian law, which demands concrete evidence of a threat. Another incorrect approach is to attempt to expedite the process by submitting incomplete or falsified documentation, or by misrepresenting one's background or intentions. This directly violates the integrity of the application process and is a serious legal offense, undermining the entire purpose of regulated firearm ownership. A further incorrect approach is to assume that passing the psychological and technical tests is sufficient without also addressing the genuine need requirement. While these tests are mandatory, they are only one component of the overall eligibility criteria. Neglecting the justa causa aspect means failing to meet a fundamental legal prerequisite for obtaining the permit. Professional reasoning. Professionals facing such a situation should employ a structured decision-making framework. First, they must thoroughly familiarize themselves with the current Brazilian legislation and regulations governing firearm permits, including any updates from the federal police and the Army. Second, they should conduct a comprehensive self-assessment of their eligibility against each specific requirement. Third, they must gather all necessary supporting documentation and ensure its accuracy and authenticity. Fourth, they should seek guidance from legal professionals or accredited firearm training centers if any aspect of the process is unclear. Finally, they must approach the application with honesty and transparency, understanding that compliance with the law is paramount. Question 3. Which approach would be most appropriate for a Brazilian official evaluating an application for a Porte de Arma de Fogo when the applicant has a past criminal conviction that they claim is old and legally resolved, but the conviction is for an offense that could be interpreted as demonstrating a disregard for legal authority? Option A. Deny the permit immediately upon discovering any past criminal conviction, regardless of its nature or legal resolution, to err on the side of public safety. Option B. Rely on informal feedback from local police contacts regarding the applicant's character and the perceived seriousness of the past offense to make a decision. Option C. Approve the permit based on the applicant's assurance that the past offense is old and legally resolved, assuming that minor or old offenses do not automatically disqualify an applicant. Option D. Conduct a thorough review of all submitted documentation and cross-reference the applicant's criminal record against the specific disqualifying criteria outlined in Brazilian Federal Law No. 10. 826/2003 and its implementing decrees, seeking official legal documentation regarding the disposition of the conviction. The correct answer is D. Conduct a thorough review of all submitted documentation and cross-reference the applicant's criminal record against the specific disqualifying criteria outlined in Brazilian Federal Law No. 10. 826/2003 and its implementing decrees, seeking official legal documentation regarding the disposition of the conviction. Explanation. Scenario analysis. This scenario is professionally challenging because it requires balancing an individual's right to self-defense with the state's paramount interest in public safety and the responsible regulation of firearms. The applicant's history presents a complex ethical and legal puzzle, demanding a thorough and impartial assessment that adheres strictly to Brazilian law. Misjudging the situation could lead to either an unwarranted denial of a fundamental right or a dangerous oversight that compromises public security. Correct approach analysis. The best professional practice involves a comprehensive review of all submitted documentation and a meticulous cross-referencing with the requirements outlined in Brazilian Federal Law No. 10. 826/2003 Estatuto do Desarmamento and its subsequent regulations, particularly Decree No. 9. 847/2019. This approach prioritizes objective evidence and legal compliance. The applicant's criminal record, even if seemingly minor or expunged under certain conditions, must be evaluated against the specific disqualifying criteria established by law. This includes assessing whether the offenses demonstrate a propensity for violence or a disregard for legal authority, which are critical factors in determining fitness to possess a firearm. The process requires a systematic, evidence-based decision that leaves no room for subjective bias or assumptions, ensuring that the permit is granted only if all legal prerequisites are unequivocally met. Incorrect approach is analysis. Approving the permit solely based on the applicant's assertion that the past offenses are old and resolved is a significant regulatory failure. Brazilian law does not permit a subjective interpretation of resolved without a formal legal process that explicitly removes the disqualifying effect for firearm possession. This approach bypasses the due diligence required by law and potentially overlooks disqualifying factors. Another incorrect approach is to deny the permit immediately upon discovering any past offense, regardless of its nature or legal disposition. While caution is warranted, Brazilian law requires a nuanced evaluation. Not all past offenses automatically disqualify an applicant if they have been legally addressed, and do not fall under the explicit prohibitions of the Estatuto do Desarmamento. This approach can be overly punitive and may violate the applicant's rights if the offenses are not disqualifying under the current legal framework. Finally, relying on informal assurances from local law enforcement without a formal background check and documentation review is a critical ethical and regulatory lapse. The decision-making process must be grounded in official records and legal statutes, not hearsay or informal opinions. To ensure fairness and compliance, professional reasoning, professionals tasked with evaluating firearm permit applications in Brazil must adopt a structured decision-making framework. This framework begins with a thorough understanding of Federal Law No. 10. 826/2003 and Decree No. 9. 847/2019. The process should involve 1. Meticulous verification of all submitted documents against legal requirements. 2. A comprehensive background check that includes criminal records, considering the specific nature and legal disposition of any offenses. 3. An objective assessment of whether the applicant meets all positive criteria, e.g., proven need, technical aptitude, psychological fitness, and avoids all negative criteria, e.g., criminal convictions for specific offenses, history of domestic violence. And 4. A written justification for the decision, referencing specific legal provisions. This systematic approach ensures impartiality, legal compliance, and the protection of public safety. Question 4. Investigation of an applicant's request for a concealed carry permit, Porte de Arma de Fogo, in São Paulo, Brazil, requires a decision based on a comprehensive review of submitted evidence. Which of the following approaches best aligns with the legal framework governing firearm permits in Brazil? Option A. Approval of the permit based on a personal recommendation from a respected community member, assuming the applicant is of good character. Option B. A thorough verification of all statutory requirements, including proof of lawful employment or legitimate need, technical and psychological aptitude certifications, and a clean criminal record, ensuring strict adherence to Federal Law No. 10. 826/2003 and its regulations. Option C. Denial of the permit because the applicant resides in a neighborhood with a statistically high incidence of violent crime. Irrespective of other qualifications, Option D. Issuance of the permit contingent upon the applicant's verbal assurance of responsible firearm handling, without requiring the mandatory technical and psychological evaluations. The correct answer is B. A thorough verification of all statutory requirements, including proof of lawful employment or legitimate need, technical and psychological aptitude certifications, and a clean criminal record, ensuring strict adherence to Federal Law No. 10. 826/2003 and its regulations. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate complex legal requirements and demonstrate a clear understanding of the responsibilities associated with firearm ownership in Brazil. The decision-making process for approving or denying a concealed carry permit involves balancing individual rights with public safety concerns, necessitating a thorough and objective evaluation of all submitted documentation and the applicant's background. Failure to adhere strictly to the legal framework can lead to improper permit issuance or unjustified denial, both of which have significant legal and societal consequences. Correct approach analysis. The best professional practice involves a meticulous review of all documentation submitted by the applicant to ensure strict compliance with the requirements outlined in Brazilian Federal Law No. 10. 826/2003, Estatuto do Desarmamento, and its subsequent regulations, particularly Decree No. 9. 847/2019. This includes verifying the applicant's proof of lawful employment or legitimate need for self-defense, demonstrating technical and psychological aptitude through certified courses and evaluations, and confirming a clean criminal record. The decision must be based solely on whether the applicant meets all statutory criteria, without personal bias or external pressure. This approach is correct because it upholds the rule of law, ensures due process for the applicant, and prioritizes public safety by adhering to established legal standards for firearm possession. Incorrect approach is analysis. One incorrect approach is to approve the permit based on a personal acquaintance with the applicant or a perceived good character, without rigorously verifying all required documentation. This fails to comply with the legal mandate to assess objective criteria and introduces subjective bias, potentially overlooking disqualifying factors and compromising public safety. Another incorrect approach is to deny the permit solely because the applicant lives in an area with a high crime rate, even if they meet all other legal requirements. Crime rates are a consideration for the asterisk justification asterisk of a permit. They do not automatically disqualify an applicant who otherwise fulfills the statutory prerequisites for demonstrating a legitimate need. This approach misinterprets the law by creating an arbitrary barrier, not explicitly stated in the legislation. A further incorrect approach is to approve the permit based on the applicant's promise to be responsible with the firearm, without requiring proof of the mandatory technical and psychological evaluations. This bypasses essential safety measures mandated by law, such as demonstrating proficiency and mental fitness, thereby increasing the risk of misuse and failing to uphold the public safety objectives of the firearm control legislation. Professional reasoning. Professionals tasked with evaluating concealed carry permit applications in Brazil should employ a structured decision-making framework. This framework begins with a comprehensive understanding of Federal Law No. 10-826/2003 and its implementing decrees. The process should involve a systematic checklist of all required documents and certifications. Each piece of evidence must be objectively assessed against the legal criteria. Any discrepancies or missing information should be addressed through formal requests for clarification or additional documentation from the applicant. The final decision must be documented thoroughly, clearly articulating how the applicant either met or failed to meet each specific legal requirement. This methodical and legally grounded approach ensures fairness, consistency, and adherence to the law, thereby safeguarding both individual rights and public security. Question 5. Assessment of an applicant for a Porte de Arma de Fogo in São Paulo, Brazil, reveals a past arrest for assault charges that were subsequently dismissed by the court due to insufficient evidence. The applicant has no other criminal convictions. Which of the following approaches best reflects the professional and regulatory requirements for processing this application? Option A. Grant the permit application based on the applicant's statement that the charges were minor and dismissed, without independently verifying the case details. Option B. Approve the permit application without further investigation, as the applicant has no formal convictions on their record. Option C. Automatically deny the permit application because the applicant was previously arrested, regardless of the charges being dismissed. Option D. Conduct a thorough review of the dismissed assault charges, examining the case details and the reasons for dismissal, to determine if the applicant's history still raises concerns about their suitability and adherence to public safety principles, while also verifying the absence of any other disqualifying factors. The correct answer is D. Conduct a thorough review of the dismissed assault charges, examining the case details and the reasons for dismissal, to determine if the applicant's history still raises concerns about their suitability and adherence to public safety principles, while also verifying the absence of any other disqualifying factors. Explanation. Scenario analysis. This scenario is professionally challenging because it requires balancing an individual's right to self-defense with the stringent public safety regulations governing firearm possession in Brazil. The applicant's history presents a complex ethical and legal puzzle, demanding a thorough understanding of the Porte de Arma de Fogo requirements beyond mere procedural checks. The challenge lies in interpreting the spirit of the law, which prioritizes public safety, against the letter of the law, which outlines specific eligibility criteria. Correct approach analysis. The best professional approach involves a comprehensive review of the applicant's entire history, specifically scrutinizing the details of the past criminal proceedings and their resolution. This approach is correct because Brazilian law, particularly under the Estatuto do Desarmamento, Disarmament Statute Law No. 10-826/2003, emphasizes the applicant's suitability and good conduct. A thorough investigation into the nature of the previous charges, the evidence presented, the outcome, acquittal, dismissal, or conviction, and the time elapsed since the proceedings is crucial to determine if the applicant genuinely meets the requirement of not having a criminal record that compromises their capacity for responsible firearm ownership. This aligns with the principle of public safety inherent in firearm licensing. Incorrect approach is analysis. One incorrect approach is to automatically deny the permit solely based on the existence of past criminal proceedings, regardless of their outcome or the applicant's subsequent conduct. This fails to acknowledge that acquittals or dismissals do not constitute a criminal record in the sense that would disqualify an applicant. It also overlooks the legal principle that individuals are presumed innocent until proven guilty, and that past legal issues, if resolved favorably, should not perpetually bar an individual from exercising their rights if they otherwise meet current criteria. Another incorrect approach is to grant the permit without a detailed examination of the past proceedings, relying only on the absence of a formal conviction. This is a significant regulatory failure. The law requires an assessment of the applicant's idoneity, suitability, which extends beyond a simple check for convictions. The nature of the charges, even if not resulting in a conviction, could indicate a propensity for violence or disregard for the law, which are critical factors in determining suitability for firearm possession. A further incorrect approach is to approve the permit based on the applicant's assertion that the charges were minor and dismissed, without independent verification. This bypasses the due diligence required by the licensing authority. The responsibility lies with the authority to verify all information provided and to conduct its own thorough investigation to ensure compliance with the Estatuto do Desarmamento and relevant decrees, such as Decree No. 847/2019, which details the procedures and requirements. Professional reasoning. Professionals in this field must adopt a decision-making framework that prioritizes public safety while respecting individual rights within the legal parameters. This involves 1. Thoroughly understanding the specific requirements of the Estatuto do Desarmamento and its implementing decrees. 2. Conducting a comprehensive background check that goes beyond superficial data, delving into the details of any past legal entanglements. 3. Critically evaluating the nature and outcome of past proceedings in relation to the applicant's current suitability. 4. Verifying all information independently. 5. Applying a consistent and objective interpretation of the law, ensuring that decisions are based on evidence and legal precedent, not assumptions or personal biases. Question 6. System analysis indicates that a resident of Sao Paulo has applied for a Porte de Arma de Fogo and disclosed a past incident involving a physical altercation, which was investigated by the police but did not result in a criminal conviction. The applicant claims the incident was in self-defense and asserts a current need for a firearm due to perceived threats. What is the most professionally sound approach to evaluating this application? Option A. Issue the permit but impose additional restrictions, such as requiring the applicant to store the firearm only at home, without a full investigation into the past incident. Option B. Conduct a thorough investigation into the circumstances of the past altercation, review all available documentation, and assess the applicant's overall suitability and genuine need for self-defense, considering the incident as a relevant factor in the decision. Option C. Deny the permit solely based on the existence of a past police investigation, regardless of the outcome or the applicant's explanation. Option D. Grant the permit immediately, as the applicant has no criminal convictions and has stated a need for self-defense. The correct answer is B. Conduct a thorough investigation into the circumstances of the past altercation, review all available documentation, and assess the applicant's overall suitability and genuine need for self-defense, considering the incident as a relevant factor in the decision. Explanation. Scenario analysis. This scenario is professionally challenging because it requires balancing an individual's right to self-defense with the state's paramount interest in public safety and the responsible regulation of firearms. The applicant's past behavior, even if not resulting in a criminal conviction, raises concerns about their suitability to carry a firearm, demanding a thorough and objective assessment beyond a simple check of criminal records. The decision-maker must navigate the nuances of Brazilian law, specifically the requirements for obtaining a Porte de Arma de Fogo, which emphasizes not only the absence of criminal convictions, but also a demonstrated capacity for responsible firearm ownership and a genuine need for self-defense. Correct approach analysis. The best professional approach involves a comprehensive evaluation of the applicant's entire history, including the circumstances surrounding the past incident, even if it did not lead to a conviction. This approach aligns with the spirit and letter of Brazilian firearm legislation, which aims to ensure that only responsible and law-abiding citizens are granted the privilege of carrying firearms. Specifically, the law requires proof of an effective need for self-defense and a demonstration of psychological fitness and technical proficiency. A thorough investigation into the past incident, even without a conviction, can reveal character traits or behavioral patterns that might indicate a risk to public safety or a lack of the necessary responsibility for firearm possession. This includes reviewing police reports, interviewing witnesses if possible, and assessing the applicant's overall demeanor and stated reasons for seeking the permit. This holistic review is crucial for fulfilling the legal mandate of ensuring public safety. Incorrect approaches analysis. One incorrect approach is to solely rely on the absence of a criminal conviction. This fails to acknowledge that Brazilian law requires more than just a clean criminal record. It necessitates a demonstration of genuine need and psychological suitability. Ignoring the circumstances of the past incident, even without a conviction, overlooks potential red flags regarding the applicant's temperament and judgment, which are critical factors in firearm permit decisions. Another incorrect approach is to grant the permit based solely on the applicant's assertion of a need for self-defense without independent verification or a deeper investigation into their background. This bypasses the legal requirement to establish an effective need and fails to adequately assess the applicant's suitability, potentially putting the public at risk. Finally, an incorrect approach would be to deny the permit solely based on the past incident, without a thorough investigation into its specifics, and without considering the applicant's subsequent behavior or any mitigating factors. While the incident is relevant, a decision must be based on a complete and fair assessment, not on a presumption of unsuitability without due process. Professional reasoning. Professionals tasked with evaluating firearm permit applications in Brazil should adopt a structured decision-making framework. This framework begins with a thorough understanding of the relevant legislation, including the requirements for effective need, psychological fitness, and technical proficiency. It then involves a comprehensive background check that goes beyond criminal records to include any documented incidents, even those not resulting in conviction. This is followed by an objective assessment of the applicant's stated need and their overall suitability, considering all available information. The decision should be based on a preponderance of evidence, ensuring that the applicant meets all legal criteria and poses no undue risk to public safety. Question 7. Risk assessment procedures indicate that an applicant for a Porte de Arma de Fogo in São Paulo, Brazil, has submitted a psychological evaluation deemed satisfactory by the issuing authority and has passed the required firearm proficiency test. However, the applicant's written justification for the permit primarily cites a general increase in crime rates within their neighborhood and a personal feeling of insecurity, without detailing specific documented threats or a demonstrable, immediate risk to their person, considering the requirements of Brazilian Federal Law No. 10-826/2003, which of the following approaches best aligns with the legal and ethical obligations for processing this application? Option A. Approve the permit based on the satisfactory psychological evaluation and proficiency test, as the general increase in crime and personal insecurity are sufficient indicators of need in a high-crime urban environment like São Paulo. Option B. Request a new psychological evaluation and a more advanced firearms training course, assuming the current submissions indicate a potential underlying issue or a lack of preparedness, even though the initial assessments were deemed satisfactory. Option C. Deny the permit solely because the applicant's justification relies on general crime statistics and personal feelings, without requiring any further investigation into specific threats, as this level of justification is inherently insufficient under Brazilian law. Option D. Thoroughly review the submitted psychological evaluation and proficiency test results, and request further detailed information from the applicant regarding specific, documented threats or circumstances that establish a demonstrable and immediate need for carrying a firearm, in accordance with the legal requirements for justification. The correct answer is D. Thoroughly review the submitted psychological evaluation and proficiency test results, and request further detailed information from the applicant regarding specific, documented threats or circumstances that establish a demonstrable and immediate need for carrying a firearm, in accordance with the legal requirements for justification. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate complex legal requirements and demonstrate a genuine need for firearm possession, balancing personal safety concerns with public security mandates. The decision-making process for approving or denying a concealed carry permit in Brazil involves a thorough assessment of the applicant's background, psychological fitness, and the justification for carrying a firearm. Misinterpreting or misapplying the legal criteria can lead to either an unwarranted denial of a legitimate request or, more critically, the approval of a permit for an individual who poses a risk to public safety. The responsibility lies with the authorizing body to ensure strict adherence to the Porte de Arma de Fogo regulations. Correct approach analysis. The best professional approach involves a meticulous review of all submitted documentation, including the psychological evaluation, proof of technical proficiency, and the detailed justification for the permit request, cross-referencing each element against the specific requirements outlined in Brazilian Federal Law No. 10. 826/2003, Estatuto do Desarmamento, and its subsequent decrees and regulations. This approach prioritizes a comprehensive understanding of the applicant's circumstances and their alignment with the legal framework, ensuring that the decision is based on objective criteria and a thorough evaluation of risk and necessity. The law mandates that applicants demonstrate both the technical capacity and the legitimate need to carry a firearm, and this approach directly addresses those mandates by verifying all supporting evidence. Incorrect approach is analysis. One incorrect approach is to grant the permit based solely on the applicant's stated fear of crime, without requiring concrete evidence or a detailed explanation of the specific threats faced. This fails to meet the legal requirement of demonstrating a legitimate and demonstrable need, as outlined in the Estatuto do Desarmamento, which goes beyond general societal concerns. Another incorrect approach is to deny the permit solely because the applicant lives in a high-crime area, without a thorough evaluation of their individual circumstances, psychological assessment, and technical proficiency. While crime rates are a factor, the law requires an individualized assessment, not a blanket denial based on geographical location. A further incorrect approach is to overlook discrepancies or omissions in the submitted documentation, such as an incomplete psychological evaluation or a lapsed technical proficiency certificate. This bypasses crucial verification steps mandated by law, potentially approving a permit for an unqualified individual. Professional reasoning. Professionals in this field should employ a structured decision-making framework that begins with a thorough understanding of the relevant Brazilian legislation, particularly Federal Law No. 10. 826/2003, and its implementing decrees. This framework should include a systematic review of all application components, a verification of the applicant's background and psychological fitness, and a critical assessment of the stated need for firearm possession. The process should be objective, evidence-based, and consistently applied to ensure fairness and public safety. Any doubts or ambiguities should be resolved by seeking clarification or additional documentation, rather than making assumptions or proceeding with incomplete information. Question 8. System analysis indicates a resident of São Paulo, Brazil, wishes to obtain a permit to carry a firearm, considering the legal framework established by Law No. 10. 826/2003 and its subsequent regulations. Which of the following actions represents the most prudent and legally compliant pathway to achieve this objective? Option A. Provide a sworn statement attesting to good character and intent, bypassing the formal requirements for psychological and technical evaluations, as personal assurances should suffice for permit approval. Option B. Attempt to expedite the process by submitting an incomplete set of documents to the federal police, hoping that the application will be processed quickly and address any missing items later. Option C. Purchase the desired firearm first from a licensed dealer and then initiate the permit application process, assuming the purchase will legitimize the subsequent application. Option D. Meticulously gather all required documentation, including proof of residency, employment, successful completion of psychological and technical aptitude assessments from accredited professionals, and a clean criminal record, and submit these sequentially to the federal police for acquisition authorization, followed by the necessary steps for registration and permit issuance as per legal requirements. Correct answer is D. Meticulously gather all required documentation, including proof of residency, employment, successful completion of psychological and technical aptitude assessments from accredited professionals, and a clean criminal record, and submit these sequentially to the federal police for acquisition authorization, followed by the necessary steps for registration and permit issuance as per legal requirements. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate a complex legal and bureaucratic process in Brazil for obtaining a firearm permit. The challenge lies in understanding and correctly applying the specific requirements of the federal police, Polícia Federal, and the Brazilian Army, Exército Brasileiro, which oversee different aspects of firearm regulation. Misinterpreting or failing to meet any single requirement can lead to denial of the permit, potential legal repercussions, and a significant delay in the applicant's ability to legally possess a firearm. The decision-making process must be meticulous, ensuring all documentation is accurate, all prerequisites are met, and the applicant's profile aligns with the stringent criteria established by Brazilian law. Correct approach analysis. The best professional approach involves a thorough and sequential adherence to the legal framework governing firearm permits in Brazil, as established by Law No. 10.826/2003, Estatuto do Desarmamento, and subsequent decrees and regulations. This means meticulously gathering all required documentation, including proof of residency, employment, psychological and technical aptitude assessments, and a clean criminal record, and submitting them in the correct order to the designated authorities. Specifically, the applicant must first obtain authorization from the federal police for the acquisition of the firearm, and then proceed with the registration and issuance of the Porte de Arma de Fogo, permit to carry, through the appropriate channels, which may involve the Brazilian Army depending on the specific type of permit and firearm. This systematic and compliant approach ensures that all legal prerequisites are met, minimizing the risk of rejection and upholding the integrity of the firearm licensing process. Incorrect approaches analysis. One incorrect approach would be to attempt to bypass or expedite the process by submitting incomplete documentation or relying on informal channels. This directly violates the procedural requirements mandated by Brazilian law, such as the need for specific psychological and technical evaluations conducted by accredited professionals. Such an approach risks immediate rejection and could lead to accusations of attempting to circumvent legal firearm acquisition processes. Another incorrect approach would be to focus solely on acquiring the firearm without first securing the necessary permits and authorizations. Brazilian law clearly delineates a sequential process where the acquisition authorization must precede the purchase and subsequent registration. Ignoring this order means the applicant is attempting to acquire a firearm illegally, which carries severe legal penalties. A further incorrect approach would be to provide inaccurate or misleading information on the application forms. This constitutes a falsification of documents, a serious offense under Brazilian law, and would result in the permanent denial of any firearm permit and potential criminal charges. Professional reasoning. Professionals involved in assisting applicants with firearm permits in Brazil must adopt a decision-making framework centered on strict legal compliance and procedural integrity. This involves 1. Thoroughly understanding the current legislation and regulatory updates from the federal police and Brazilian Army. 2. Conducting a comprehensive pre-application assessment of the applicant's eligibility and documentation. 3. Guiding the applicant through each step of the process in the correct sequence, emphasizing the importance of accuracy and completeness in all submissions. 4. Maintaining open communication with the applicant regarding progress and any potential issues. 5. Prioritizing ethical conduct and advising against any shortcuts or misrepresentations that could jeopardize the application or lead to legal trouble. Question 9. Compliance review shows an applicant for a Porte de Arma de Fogo in São Paulo, Brazil, has submitted a psychological evaluation certificate issued by a psychologist accredited by the federal police. The applicant states the evaluation was conducted 2 years ago, and the psychologist's accreditation has since lapsed. What is the most appropriate course of action regarding the psychological evaluation? Option A. Accept the psychological evaluation without confirming its validity period, assuming it is current. Option B. Accept the psychological evaluation as valid if it was issued by an accredited professional and is within its stipulated validity period, regardless of the psychologist's current accreditation status. Option C. Reject the application because the psychologist who conducted the evaluation is no longer registered with the federal police. Option D. Reject the application, as any psychological evaluation conducted more than 1 year prior to the application is automatically invalid. The correct answer is B. Accept the psychological evaluation as valid if it was issued by an accredited professional and is within its stipulated validity period, regardless of the psychologist's current accreditation status. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a nuanced understanding of the specific requirements for obtaining and maintaining a firearm permit in Brazil, particularly concerning the psychological evaluation. Misinterpreting or overlooking the validity period of such evaluations can lead to serious legal and ethical breaches, jeopardizing the applicant's rights and the integrity of the permitting process. The core challenge lies in distinguishing between a completed evaluation and one that remains valid for the purposes of the permit application. Correct approach analysis. The best professional approach involves verifying the current validity of the psychological evaluation certificate. According to Brazilian law, specifically Law No. 10. 826/2003, Estatuto do Desarmamento, and its subsequent regulations, such evaluations must be conducted by professionals accredited by the federal police and have a defined validity period. If the certificate is within its validity period, it should be accepted as fulfilling the requirement. This approach is correct because it adheres strictly to the legal framework governing firearm permits in Brazil, ensuring that all procedural requirements are met within their stipulated timeframes. Incorrect approaches analysis. One incorrect approach is to reject the application solely because the psychological evaluation was conducted by a psychologist who is no longer registered with the federal police, even if the evaluation itself was valid at the time it was issued and within its stipulated validity period. This is incorrect because the validity of the evaluation is tied to its issuance date and the psychologist's accreditation at that specific time, not necessarily their current registration status, provided the evaluation meets all other legal criteria. Another incorrect approach is to accept the psychological evaluation without confirming its validity period. This is a failure to comply with the regulatory requirement that the evaluation must be current and relevant to the applicant's current psychological state at the time of application. The law mandates a recent evaluation to ensure the applicant's continued fitness to possess a firearm. A further incorrect approach is to assume that any psychological evaluation, regardless of its origin or recency, is sufficient as long as the applicant claims to have passed it. This disregards the specific legal requirements for accredited professionals and valid certificates, undermining the safety and regulatory integrity of the firearm permitting process in Brazil. Professional reasoning. Professionals in this field must adopt a systematic approach. First, they should clearly understand the specific legal requirements for each document and certification, including validity periods and issuing authorities. Second, they must meticulously verify each document against these requirements. Third, when faced with ambiguity, they should consult the relevant legislation or seek guidance from their superiors or legal counsel. The decision-making process should prioritize strict adherence to the law and the protection of public safety, ensuring that all permits are issued only to individuals who demonstrably meet all legal criteria. Question 10. Compliance review shows that a firearm permit renewal application in Sao Paulo, Brazil, requires a fee calculation based on the previous year's fee of R$350,000. The official annual inflation index, IPCA, for the preceding year was 7.5%. The maximum statutory fee for renewal, as per Brazilian Federal Law No. 10. 826/2003, is R$400,000. What is the correct renewal fee to be charged? Option A, R$350,000. Option B, R$376.25. Option C, R$400,000. Option D, R$378,000. The correct answer is B, R$376.25. Explanation. Scenario analysis. This scenario presents a professional challenge due to the need to accurately calculate and interpret firearm permit renewal fees, which are subject to specific legal provisions in Brazil. Misinterpreting these provisions can lead to financial penalties for the applicant and potential regulatory noncompliance for the issuing authority. The core difficulty lies in applying the correct percentage increase based on the specified annual inflation index and ensuring the final fee does not exceed the statutory maximum, all within the framework of Brazilian firearm legislation. Correct approach analysis. The best professional practice involves a precise calculation of the renewal fee by first determining the base fee, then applying the legally mandated inflation adjustment, and finally verifying that the adjusted fee does not surpass the statutory cap. This approach ensures full compliance with Brazilian Federal Law No. 10-826/2003, Estatuto do Desarmamento, and its subsequent amendments, which govern firearm possession and renewal processes. Specifically, Article 10 of the law, as amended, outlines the renewal requirements and associated fees, which are subject to adjustments based on official indices. The calculation must be transparent and directly reflect the legal requirements, preventing overcharging or undercharging. Incorrect approaches analysis. One incorrect approach involves simply applying the inflation index to the previous year's fee without considering the statutory maximum fee. This fails to adhere to the legal cap, potentially resulting in a fee that exceeds what is permitted by law, thereby violating Article 10 of Federal Law No. 10-826/2003. Another incorrect approach is to use a fixed percentage increase that is not tied to the official inflation index, e.g., IPCA, as stipulated by Brazilian law. This disregards the specific mechanism for fee adjustment mandated by the legislation, leading to an arbitrary and non-compliant fee. A third incorrect approach is to ignore the inflation adjustment altogether and charge the same fee as the previous year, even if the official inflation index indicates a required increase. This also violates the legal requirement for periodic fee adjustments based on economic indicators, as outlined in the relevant articles of the Estatuto do Desarmamento. Professional reasoning. Professionals in this field must adopt a systematic approach to fee calculation. This involves 1. Identifying the current base fee for firearm permit renewal. 2. Determining the official annual inflation index, e.g., IPCA, for the relevant period as published by the Brazilian Institute of Geography and Statistics IBGE. 3. Calculating the adjusted fee by applying the inflation index to the base fee, / adjusted fee equals base fee / times 1 plus inflation rate, / 4. Comparing the adjusted fee with the statutory maximum fee. If the adjusted fee exceeds the maximum, the statutory maximum fee must be applied. This methodical process ensures accuracy, fairness, and strict adherence to Brazilian firearm legislation. Question 11. Process analysis reveals that a prominent Brazilian entrepreneur, whose business activities involve significant financial transactions and public visibility, is seeking a concealed carry of a firearm permit, Porte de Arma de Fogo, primarily citing personal protection, due to the perceived risks associated with their high-profile role. Given the specific regulatory framework for obtaining such a permit in Brazil, which approach best aligns with the legal requirements and professional ethical standards for assisting this applicant? Option A. Submit an application based on vague assertions of potential danger without providing any concrete evidence or documentation of specific threats, relying on the applicant's status to imply a need. Option B. Frame the primary purpose of the firearm as being for business security, leveraging the perceived risks of their profession to satisfy permit requirements. Option C. Argue that the applicant's high-profile business inherently creates a risk, making a firearm permit for personal protection a necessary consequence of their professional standing. Option D. Meticulously document the applicant's specific, demonstrable threats and the direct link between their business activities and these threats, thereby justifying the need for a firearm for personal protection under the existing legal framework for a Porte de Arma de Fogo. The correct answer is D. Meticulously document the applicant's specific, demonstrable threats and the direct link between their business activities and these threats, thereby justifying the need for a firearm for personal protection under the existing legal framework for a Porte de Arma de Fogo. Explanation. Scenario analysis. This scenario is professionally challenging because it requires navigating the complex and evolving legal landscape surrounding firearm ownership in Brazil, specifically concerning the distinction between personal defense and professional security needs for a firearm permit. Misinterpreting the requirements or misrepresenting one's situation can lead to severe legal repercussions, including criminal charges and the denial or revocation of permits. The applicant's stated need for a firearm for personal protection, while simultaneously being a prominent figure in a potentially high-risk business environment, necessitates careful scrutiny to ensure compliance with the Porte de Arma de Fogo regulations. Correct approach analysis. The best professional approach involves meticulously documenting the applicant's specific, demonstrable threats and the direct link between their business activities and these threats, thereby justifying the need for a firearm for personal protection under the existing legal framework for a Porte de Arma de Fogo. This means providing evidence of concrete risks, not generalized fears, and showing how these risks directly impact the applicant's personal safety due to their professional role. This aligns with the spirit and letter of Brazilian law, which requires a genuine and demonstrable need for self-defense, often linked to the individual's circumstances, rather than an assumption of risk based solely on profession. The applicant must prove they are not merely seeking a firearm for convenience or because their profession is generally perceived as risky, but because they face specific, documented threats that necessitate armed self-defense. Incorrect approach is analysis. One incorrect approach is to solely rely on the applicant's profession as justification for a firearm permit, arguing that their high-profile business inherently creates a risk. This fails because Brazilian law requires more than a generalized assumption of risk. It demands specific, demonstrable threats directly impacting the applicant's personal safety. Simply being in a visible or potentially lucrative profession does not automatically equate to a direct, personal threat that warrants a firearm permit. Another incorrect approach is to misrepresent the primary purpose of the firearm as solely for business security rather than personal protection, hoping to leverage different, potentially more lenient, regulations. This is ethically and legally problematic. The application for a Porte de Arma de Fogo is for personal self-defense. Attempting to reframe the need to fit a different category or to circumvent the personal protection requirements constitutes misrepresentation and can lead to the denial or revocation of the permit, as well as potential criminal charges for providing false information. A further incorrect approach is to submit an application based on vague assertions of potential danger, without providing any concrete evidence or documentation of specific threats. This approach lacks the necessary substantiation required by Brazilian authorities. The process demands a clear and verifiable link between the applicant's circumstances and the need for a firearm for personal protection. Vague claims are insufficient to meet the burden of proof. Professional reasoning. Professionals assisting applicants for a Porte de Arma de Fogo in Brazil must adopt a rigorous, evidence-based approach. This involves thoroughly understanding the applicant's personal circumstances, identifying any specific threats, and gathering all supporting documentation. The focus should always be on demonstrating a genuine and demonstrable need for personal protection, directly linked to the applicant's life and circumstances, in strict accordance with the requirements of Brazilian firearm legislation. Transparency and accuracy in all representations are paramount. Question 12. Governance review demonstrates that a client in São Paulo, Brazil, is seeking guidance on obtaining a concealed carry permit, Porte de Arma de Fogo. Considering the current federal regulatory framework, which of the following approaches best aligns with legal and ethical professional practice for advising this client? Option A. Thoroughly explain the federal eligibility criteria, including psychological and technical aptitude, background checks, and the necessity of demonstrating a legitimate need, as mandated by federal law and its most recent decrees, and guide them through the official application process with the federal police. Option B. Suggest that the client can expedite the process by obtaining a firearm first and then addressing the permit requirements, or by seeking informal channels that bypass official federal procedures. Option C. Advise the client to follow the procedures and requirements that were common in other Brazilian states prior to the most recent federal decree, assuming these practices are still broadly applicable. Option D. Inform the client that state-level regulations in São Paulo are the primary determinant for concealed carry permits, and that federal requirements are secondary or can be interpreted loosely. The correct answer is A. Thoroughly explain the federal eligibility criteria, including psychological and technical aptitude, background checks, and the necessity of demonstrating a legitimate need, as mandated by federal law and its most recent decrees, and guide them through the official application process with the federal police. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms instructor in Brazil, who is tasked with advising a client on the concealed carry permit, Porte de Fogo process. The challenge lies in navigating the complex and evolving legal landscape surrounding firearm ownership and carry, particularly concerning the specific requirements and interpretations of federal law and its interaction with potential state-level nuances, while ensuring the client receives accurate and legally sound advice. Misinterpreting or misapplying regulations can lead to severe legal consequences for both the client and the instructor. Correct approach analysis. The best professional practice involves a thorough and up-to-date understanding of the federal legislation governing firearm possession and concealed carry in Brazil, primarily Decree No. 11. 615 of 2023, which regulates Law No. 10. 826 of 2003, Estatuto do Desarmamento. This approach necessitates advising the client on the precise eligibility criteria, including psychological and technical aptitude assessments, background checks, and the demonstration of a legitimate need to carry a firearm, as stipulated by federal law. It also requires guiding the client through the correct application procedures with the competent federal authority, currently the federal police for most civilians. This is correct because it adheres strictly to the established federal legal framework, ensuring the client's application is compliant and maximizing their chances of approval while minimizing legal risks. Ethical practice demands providing accurate, current, and legally defensible information. Incorrect approaches analysis. Advising the client to rely solely on outdated information or anecdotal evidence from other states regarding concealed carry requirements is professionally unacceptable. This approach fails to acknowledge the supremacy of federal law and the potential for differing interpretations or enforcement practices that could render such advice invalid. It risks leading the client to believe they meet requirements that are no longer applicable or have been superseded by federal decree, resulting in a denied application or, worse, illegal possession. Suggesting that the client can bypass certain federal requirements by obtaining a permit through a less stringent, informal process, or by assuming state-level regulations supersede federal ones, is a critical regulatory failure. Federal law, particularly the Estatuto do Desarmamento and its subsequent decrees, establishes the national standard for firearm possession and carry. Any attempt to circumvent these federal mandates is illegal and unethical, exposing both the client and the instructor to severe legal penalties. Recommending that the client focus primarily on acquiring a firearm and then worry about the permit process later, or assuming that simply owning a firearm automatically grants carry rights, demonstrates a fundamental misunderstanding of Brazilian firearms law. The law clearly separates possession, posse, from carry, porte, with distinct requirements for each. Prioritizing firearm acquisition over the legal framework for carrying it is a direct violation of the law and an abdication of professional responsibility. Professional reasoning. Professionals in this field must adopt a decision-making process rooted in continuous learning and strict adherence to the governing legal framework. This involves 1. Staying meticulously updated on all federal legislation and decrees pertaining to firearms, including any amendments or new regulations. 2. Verifying the current requirements and procedures directly with the official federal authorities responsible for issuing permits. 3. Clearly differentiating between firearm possession and concealed carry rights and their respective legal prerequisites. 4. Providing advice that is not only legally compliant but also ethically sound, prioritizing the client's understanding of their rights and responsibilities under the law. 5. Documenting all advice given to protect both the professional and the client. Question 13. What factors determine the eligibility of an individual seeking a concealed carry firearm permit Porte de Arma de Fogo in Brazil, beyond simply expressing a desire for self-defense? Option A. Successful completion of a federally accredited psychological evaluation and a firearms proficiency test, alongside a verifiable clean criminal record and proof of lawful employment. Option B. A notarized declaration of intent to use the firearm solely for personal protection, and the submission of a recent utility bill as proof of residency. Option C. The applicant's perceived social standing within their community and a demonstration of basic familiarity with firearm safety. Option D. A sworn statement from the applicant attesting to their need for self-defense and a letter of recommendation from a local community leader. The correct answer is A. Successful completion of a federally accredited psychological evaluation and a firearms proficiency test, alongside a verifiable clean criminal record and proof of lawful employment. Explanation. Scenario analysis. This scenario is professionally challenging because it requires navigating the nuanced requirements for obtaining a firearm permit in Brazil, specifically the Porte de Arma de Fogo, which involves demonstrating both technical aptitude and psychological fitness. The challenge lies in accurately interpreting and applying the legal criteria, ensuring all documentation is complete and verifiable, and understanding the subjective elements involved in the psychological evaluation. Misinterpreting any aspect can lead to denial of the permit, potential legal repercussions, or even endangerment if an unqualified individual obtains a firearm. Correct approach analysis. The best professional approach involves a thorough understanding and meticulous adherence to the specific requirements outlined in Brazilian Federal Law No. 10. 826/2003, Lei do Desarmamento, and its subsequent regulations, particularly Decree No. 9. 847/2019. This includes ensuring the applicant meets all objective criteria such as age, clean criminal record, proof of lawful employment, and residency. Crucially, it also necessitates successful completion of the mandatory psychological evaluation conducted by a psychologist accredited by the federal police and the firearms proficiency test administered by a qualified instructor accredited by the federal police. The applicant must present all required documentation, including proof of technical and psychological capacity, to the federal police for review and approval. This approach is correct because it directly aligns with the legal framework established by Brazilian law, which mandates these specific evaluations and documentation as prerequisites for permit issuance. Incorrect approaches analysis. One incorrect approach would be to solely focus on the applicant's stated intent to carry a firearm for self-defense without rigorously verifying their psychological fitness or ensuring they have completed the mandated proficiency training. This fails to address the legal requirement for a psychological evaluation and the demonstration of safe firearm handling skills, potentially leading to the issuance of a permit to an individual who is not psychologically stable or technically competent, thereby violating the spirit and letter of the law designed to ensure public safety. Another incorrect approach would be to submit incomplete or falsified documentation regarding the applicant's criminal record or employment status. Brazilian law requires a thorough background check, and any misrepresentation or omission of relevant information is grounds for denial and can carry legal penalties. This approach disregards the integrity of the application process and the legal obligation to provide truthful information. A further incorrect approach would be to rely on informal recommendations or personal assurances from individuals without ensuring the applicant has formally completed and passed the officially recognized psychological and firearms proficiency assessments. The law specifies accredited professionals and formal testing procedures, and bypassing these established channels renders the application invalid and potentially dangerous. Professional reasoning. Professionals involved in assisting applicants for a firearm permit in Brazil should adopt a systematic, compliance-driven approach. This involves 1. Thoroughly familiarizing themselves with the current Brazilian legislation, Federal Law No. 10. 826/2003 and Decree No. 9. 847/2019, and any updates. 2. Guiding the applicant through each mandatory step, including the psychological evaluation by an accredited professional and the firearms proficiency test. 3. Ensuring all documentation is accurate, complete, and submitted within the stipulated timelines to the federal police. 4. Maintaining transparency with the applicant about the process and potential outcomes. This structured methodology ensures adherence to legal requirements, promotes responsible firearm ownership, and mitigates risks associated with improper permit issuance. Question 14. Compliance review shows an applicant for a Porte de Arma de Fogo in Sao Paulo, Brazil, has submitted a psychological evaluation report indicating they are psychologically fit. However, the applicant has a minor infraction from several years ago that they claim was resolved. What is the most appropriate course of action for the licensing authority? Option A. Issue the firearm permit based on the submitted psychological evaluation, assuming the applicant's self-declaration about the resolved infraction is sufficient. Option B. Reject the application outright based on the mere mention of a past infraction, without further investigation into its specifics or resolution. Option C. Expedite the permit process due to the applicant's stated urgency and the seemingly minor nature of the past infraction, bypassing further investigation. Option D. Conduct a thorough verification of the psychological evaluation and investigate the nature and resolution of the past infraction to ensure compliance with Brazilian firearm laws before proceeding. The correct answer is D. Conduct a thorough verification of the psychological evaluation and investigate the nature and resolution of the past infraction to ensure compliance with Brazilian firearm laws before proceeding. Explanation. Scenario analysis. This scenario is professionally challenging because it requires navigating the nuanced requirements for obtaining a firearm permit in Brazil, specifically the Porte de Arma de Fogo, while also considering the applicant's recent history. The challenge lies in balancing the applicant's right to self-defense with the state's responsibility to ensure public safety by preventing firearms from falling into the wrong hands. A thorough understanding of the legal framework, including the specific criteria for psychological evaluation and the implications of past legal issues, is paramount. Correct approach analysis. The best professional approach involves a meticulous review of the applicant's psychological evaluation results, ensuring they meet the stringent requirements stipulated by Brazilian law for firearm possession, and cross-referencing this with any available information regarding past legal entanglements. This approach is correct because Brazilian legislation, particularly Law No. 10.826/2003, Estatuto do Desarmamento, and its subsequent regulations, mandates a comprehensive assessment of the applicant's psychological fitness and a clean criminal record. The federal police, responsible for overseeing firearm permits, requires documented proof of psychological stability and the absence of any judicial impediments. Therefore, prioritizing a thorough, documented, and legally compliant evaluation process is essential. Incorrect approach is analysis. One incorrect approach is to solely rely on the applicant's self-declaration of good conduct and psychological well-being, without independent verification. This fails to meet the legal obligation to conduct due diligence, and can lead to the issuance of a permit to an individual who may pose a risk. Directly contravenes the spirit and letter of the Estatuto do Desarmamento, which emphasizes objective assessments. Another incorrect approach is to dismiss the applicant's past legal issues without a thorough investigation into their nature and resolution. Brazilian law considers certain past offenses as disqualifying factors for firearm permits. Ignoring this aspect, even if the applicant claims the matter is resolved, bypasses a critical regulatory requirement and compromises public safety. A third incorrect approach is to expedite the permit process based on the applicant's perceived urgency or personal circumstances, without completing all mandatory checks. This prioritizes expediency over safety and legal compliance, potentially leading to severe legal repercussions for the issuing authority and increased risk to the public. Professional reasoning. Professionals in this field must adopt a systematic and legally grounded decision-making process. This involves 1. Thoroughly understanding the specific requirements of Brazilian firearm legislation, including psychological evaluation standards and disqualifying offenses. 2. Implementing a robust verification process for all submitted documentation, including independent checks of psychological assessments and criminal records. 3. Applying the law consistently and impartially, without succumbing to external pressures or personal biases. 4. Documenting every step of the process meticulously to ensure accountability and transparency. Question 15. Compliance review shows a Brazilian citizen applying for a Porte de Arma de Fogo has a history of 2 minor infractions from over 5 years ago, neither resulting in a criminal conviction but both involving fines. What is the most prudent approach to ensure the application is processed in accordance with Brazilian federal firearm legislation? Option A. Provide a brief, generalized statement about having had minor administrative issues in the past without detailing the specific infractions, relying on the psychological evaluation to address any concerns. Option B. Omit any mention of the past minor infractions from the application, assuming they are too old and minor to be relevant to the current firearm permit application. Option C. Focus solely on obtaining a strong psychological evaluation and technical aptitude certification, believing these will automatically override any potential concerns arising from past minor infractions. Option D. Fully disclose both minor infractions to the federal police, providing details and any relevant documentation, and proceed with the standard application process, including the psychological and technical aptitude evaluations. The correct answer is D. Fully disclose both minor infractions to the federal police, providing details and any relevant documentation, and proceed with the standard application process, including the psychological and technical aptitude evaluations. Explanation. Scenario analysis. This scenario is professionally challenging because it requires navigating the nuanced requirements for obtaining a firearm permit in Brazil, specifically the Porte de Arma de Fogo, while ensuring strict adherence to federal legislation and avoiding common pitfalls that lead to permit denial. The applicant's history of minor infractions, while not disqualifying on their face, necessitates careful consideration of how these might be interpreted by the authorities and whether they impact the assessment of psychological fitness and lawful conduct. The core challenge lies in accurately assessing the applicant's eligibility based on the totality of their circumstances and the specific criteria outlined in Brazilian law, particularly Law No. 10. 826/2003 and its subsequent amendments and decrees. Correct approach analysis. The best professional approach involves a thorough and transparent disclosure of all relevant information to the federal police, including the details of the past minor infractions. This approach is correct because Brazilian law, particularly Article 10 of Law No. 10. 826/2003, mandates that applicants demonstrate proven capacity for responsible firearm ownership, which includes a clean record of lawful conduct and psychological fitness. By proactively and honestly presenting the past infractions, the applicant allows the federal police to conduct a comprehensive assessment based on all available facts, rather than risking denial due to undisclosed information. This aligns with the ethical obligation of honesty and the legal requirement to satisfy the authorities of the applicant's suitability. The psychological evaluation, as mandated by Decree No. 9. 847/2019, will also consider the applicant's overall history and character. Incorrect approaches analysis. One incorrect approach is to omit any mention of the past minor infractions, assuming they are too insignificant to matter. This is a regulatory failure because Article 10 of Law No. 10. 826/2003 requires a declaration of lawful conduct, and any attempt to conceal relevant information can be interpreted as a lack of honesty and potentially lead to permit denial or revocation if discovered later. It undermines the principle of transparency essential for firearm licensing. Another incorrect approach is to downplay the severity of the infractions without providing full context. While the infractions may be minor, the federal police are tasked with assessing the applicant's overall suitability. Presenting them in a misleading or overly minimized manner, without the full details, can be seen as an attempt to circumvent the spirit of the law, which seeks to ensure responsible gun ownership. This could lead to a negative assessment of the applicant's judgment and trustworthiness. A further incorrect approach is to rely solely on the psychological evaluation to overcome any perceived issues from the past infractions without addressing them directly in the application. While a positive psychological evaluation is crucial, it does not absolve the applicant from the requirement to demonstrate a history of lawful conduct. The federal police consider both aspects independently and in conjunction. Failing to address the infractions directly in the application process, even if they are later deemed not disqualifying by the psychologist, represents a missed opportunity for clear and proactive compliance. Professional reasoning. Professionals assisting applicants for a Porte de Arma de Fogo in Brazil should adopt a strategy of complete transparency and thorough documentation. The decision-making process should begin with a comprehensive review of the applicant's history, identifying any potential issues that might be scrutinized under Law No. 10. 826/2003 and its implementing decrees. This involves advising the applicant to disclose all relevant information, including any past legal encounters, no matter how minor they may seem. The focus should be on presenting these facts accurately and providing context, allowing the federal police to make an informed decision. Professionals must guide applicants to understand that honesty and full disclosure are paramount to a successful application and are fundamental to demonstrating the lawful conduct and responsible citizenship required for firearm possession in Brazil. Question 16. Quality control measures reveal a discrepancy in understanding the legal framework for firearm authorization in Brazil. An individual believes that having a registered firearm in their residence, as per Brazilian law, automatically permits them to carry that firearm concealed in public spaces without further authorization. What is the most accurate understanding of Brazilian firearm law in this scenario? Option A. The Estatuto do Desarmamento in Brazil primarily focuses on firearm possession, and regulations regarding concealed carry are minimal and largely left to individual interpretation. Option B. A firearm possession registration, Registro de Arma de Fogo, in Brazil does not automatically grant the right to carry a firearm concealed in public. A separate authorization, Porte de Arma de Fogo from the federal police, demonstrating a genuine need, is required. Option C. Once a firearm is registered in Brazil, the owner can carry it concealed in public, provided they do not engage in any illegal activities while doing so. Option D. If a firearm is legally registered in Brazil, the owner is implicitly authorized to carry it concealed in public, as the registration signifies responsible ownership. The correct answer is B. A firearm possession registration, Registro de Arma de Fogo, in Brazil does not automatically grant the right to carry a firearm concealed in public. A separate authorization, Porte de Arma de Fogo, from the federal police, demonstrating a genuine need, is required. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to navigate complex legal requirements and demonstrate a thorough understanding of the specific regulations governing firearm possession in Brazil, particularly concerning the distinction between mere possession and the legal right to carry concealed. Misinterpreting these nuances can lead to severe legal consequences, including criminal charges and the denial of fundamental rights. The pressure to obtain or maintain a firearm permit, coupled with the potential for misunderstanding the scope of the permit, necessitates meticulous attention to detail and adherence to established legal procedures. Correct approach analysis. The best professional practice involves diligently researching and understanding the specific requirements outlined by the Brazilian Federal Police, Polícia Federal, for obtaining a Porte de Arma de Fogo, which includes demonstrating a genuine need and undergoing rigorous psychological and technical evaluations. This approach prioritizes full compliance with the legal framework established by Law No. 10-826/2003, Estatuto do Desarmamento, and its subsequent regulations. It acknowledges that a permit for possession posse does not automatically grant the right to carry, port, concealed, and that specific authorization for carrying is a separate, more stringent process requiring justification of effective need. This approach ensures that the applicant is not only legally compliant, but also prepared to meet the high standards set by Brazilian law for responsible firearm ownership and carrying. Incorrect approaches analysis. One incorrect approach involves assuming that simply possessing a firearm legally, as evidenced by a registration, automatically grants the right to carry it concealed. This fails to recognize that Brazilian law clearly distinguishes between the right to possess a firearm in one's home or workplace and the right to carry it in public spaces. The Estatuto do Desarmamento explicitly requires a separate authorization for carrying, which is granted only under specific circumstances and after a thorough assessment of need. Another incorrect approach is to rely on informal advice or anecdotal evidence from other individuals regarding firearm carrying regulations. This bypasses the official channels and regulatory bodies responsible for issuing permits, such as the Polícia Federal. Such an approach risks misinterpreting the law, overlooking crucial procedural steps, or acting on outdated or inaccurate information, leading to potential legal repercussions. A further incorrect approach is to believe that a valid firearm possession registration is sufficient grounds for concealed carry without any further application or justification. This ignores the tiered system of authorization in Brazil, where carrying a firearm in public is a privilege, not a right, and requires a specific demonstration of need and suitability that goes beyond mere registration. Professional reasoning. Professionals facing such situations should adopt a systematic approach. First, they must identify the specific jurisdiction and the relevant governing laws and regulatory bodies. In Brazil, this means consulting the Estatuto do Desarmamento and the guidelines issued by the Polícia Federal. Second, they should differentiate between distinct legal rights, such as possession versus carrying. Third, they must seek official information directly from the authoritative source, avoiding reliance on informal channels. Finally, they should understand that compliance is not merely about meeting minimum requirements, but about demonstrating a thorough understanding and adherence to the spirit and letter of the law, especially when dealing with sensitive rights like firearm ownership and carrying. Question 17. Compliance review shows an applicant for a firearm permit in São Paulo, Brazil, has submitted a detailed personal statement outlining significant concerns for their personal safety due to their profession. However, The applicant's submitted documentation includes a psychological evaluation report that is 6 months old and a certificate of lawful occupation that is a photocopy of a photocopy. Based on Brazilian law, what is the most appropriate course of action for the permitting authority? Option A. Deny the firearm permit immediately due to the applicant's perceived high-risk situation, as evidenced by their statement, suggesting they may be an undue risk. Option B. Accept the submitted documentation as sufficient, given the applicant's stated need for self-defense, and proceed with the permit review. Option C. Issue the firearm permit based on the applicant's compelling personal safety concerns, as the intent of the law is to protect citizens. Option D. Request updated and verified documentation, including a current psychological evaluation and an original or certified copy of the proof of lawful occupation, before proceeding with the application review. Correct answer is D. Request updated and verified documentation, including a current psychological evaluation and an original or certified copy of the proof of lawful occupation, before proceeding with the application review. Explanation. Scenario analysis. This scenario is professionally challenging because it requires navigating the nuanced requirements for obtaining a firearm permit in Brazil, specifically the Porte de Arma de Fogo, while balancing the applicant's stated need for self-defense against the stringent legal prerequisites. The challenge lies in accurately assessing the applicant's eligibility and ensuring all documentation and psychological evaluations meet the standards set by Brazilian law, particularly Law No. 10. 826/2003, Estatuto do Desarmamento, and its subsequent regulations, without overstepping the bounds of the permitting authority's role. Misinterpretation or misapplication of these laws can lead to either the unlawful issuance of a permit or the unjust denial of a legitimate request. Correct approach analysis. The best professional approach involves a thorough and meticulous review of all submitted documentation, cross-referencing each item against the specific requirements outlined in Law No. 10. 826/2003 and relevant decrees, such as Decree No. 9. 847/2019. This includes verifying the applicant's proof of lawful occupation, absence of criminal records, federal, state, and municipal, and the results of the mandatory psychological and technical aptitude tests administered by accredited professionals. The focus must be on objective compliance with legal mandates, ensuring that the applicant demonstrably meets all statutory criteria for self-defense, as defined by the law, before proceeding with the permit issuance. This approach upholds the integrity of the permitting process and ensures public safety by adhering strictly to established legal frameworks. Incorrect approaches analysis. One incorrect approach would be to grant the permit based solely on the applicant's expressed fear for personal safety and their assertion of needing a firearm for self-defense, without rigorously verifying the supporting documentation and mandatory evaluation. This bypasses critical legal requirements, such as proof of legitimate occupation and the results of psychological and technical aptitude tests, thereby failing to comply with Law No. 10. 826/2003 and potentially endangering public safety. Another incorrect approach is to deny the permit based on a subjective interpretation of the applicant's perceived risk profile, without concrete evidence of noncompliance with legal requirements. This constitutes an arbitrary decision that goes beyond the established legal criteria for permit issuance and can be challenged as an abuse of authority, as Brazilian law outlines specific grounds for denial, not subjective assessments of risk. A further incorrect approach involves accepting incomplete or outdated documentation, such as expired psychological evaluation reports or unverified criminal record checks, and proceeding with the permit application. This directly violates the procedural requirements stipulated by Brazilian law, which mandates current and valid documentation for all aspects of the application, leading to an invalid permit if issued. Professional reasoning. Professionals in this field must adopt a systematic and evidence-based decision-making process. This involves 1. Clearly understanding the specific legal framework governing firearm permits in Brazil, Law No. 10. 826/2003 and its implementing decrees. 2. Establishing a checklist of all mandatory documents and evaluations required for each applicant. 3. Objectively verifying the authenticity and validity of all submitted materials against legal standards. 4. documenting every step of the review process and the rationale for any decision made. 5. Recognizing the limits of their authority and avoiding subjective judgments not supported by law. 6. Prioritizing public safety and adherence to legal due process above all else. Question 18. Compliance review shows that a Brazilian citizen is applying for a concealed carry firearm permit, Porte de Arma de Fogo, and has submitted a psychological evaluation certificate. However, the certificate was issued 18 months ago, and the applicant states they have no recent history of mental health concerns or legal troubles, urging for immediate processing. What is the most appropriate course of action for the compliance officer in Brazil? Option A. Deny the firearm permit application immediately due to the submission of an invalid psychological evaluation. Option B. Inform the applicant that the psychological evaluation has expired according to Brazilian federal police regulations, and a new, valid evaluation is required for the application to proceed. Option C. Expedite the permit process by accepting the expired evaluation, with the understanding that the applicant will obtain a new one at a later stage. Option D. Accept the psychological evaluation as valid, given the applicant's assurances of no recent issues, and proceed with the permit application. The correct answer is B. Inform the applicant that the psychological evaluation has expired according to Brazilian federal police regulations, and a new, valid evaluation is required for the application to proceed. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a nuanced understanding of the specific requirements for obtaining and maintaining a firearm permit in Brazil, particularly concerning the psychological evaluation. Misinterpreting or overlooking the validity period of such evaluations can lead to serious legal and ethical repercussions, including the denial or revocation of a permit, and potential criminal charges. The applicant's reliance on an outdated evaluation, coupled with their urgency, creates a situation where a compliance officer must strictly adhere to regulations while also managing applicant expectations. Correct approach analysis. The best professional practice involves strictly adhering to the current regulations set forth by the Brazilian Federal Police regarding the validity period of psychological evaluations for firearm permit applications. This approach requires verifying that the applicant's submitted psychological evaluation is within the stipulated timeframe for validity. If the evaluation has expired, the applicant must be informed that a new, up-to-date evaluation is mandatory for their application to proceed. This is correct because Brazilian law, specifically Decree No. 9. 847/2019, and subsequent regulations from the Federal Police, mandates that psychological aptitude assessments have a defined validity period. Submitting an expired evaluation does not meet the legal requirements for demonstrating current psychological fitness to possess a firearm, thus rendering the application incomplete and non-compliant. Incorrect approach is analysis. One incorrect approach is to accept the expired psychological evaluation based on the applicant's assertion that they have no history of mental health issues or criminal activity. This fails to comply with the explicit legal requirement for a current, valid assessment. The law does not permit exceptions based on an applicant's personal assurances. It demands objective, time-bound evidence of psychological fitness. Another incorrect approach is to expedite the permit process by overlooking the expired evaluation, assuming it will be updated later. This is a severe regulatory failure. The initial application must meet all prerequisites. Allowing an incomplete application to proceed creates a false sense of compliance and bypasses the established safety protocols designed to ensure responsible firearm ownership. It also sets a dangerous precedent for future applications. A further incorrect approach is to deny the permit outright without clearly explaining the specific deficiency regarding the psychological evaluation's validity. While the permit may ultimately be denied if a valid evaluation is not provided, the initial professional response should be to identify the specific regulatory noncompliance and provide the applicant with clear instructions on how to rectify it. A complete denial without this guidance is unprofessional and does not serve the purpose of regulatory oversight, which includes guiding applicants towards compliance where possible. Professional reasoning. Professionals in this role must adopt a systematic approach. First, thoroughly understand the specific legal and regulatory framework governing firearm permits in Brazil. Second, meticulously review all submitted documentation against these requirements, paying close attention to expiry dates and validity periods. Third, communicate any deficiencies clearly and precisely to the applicant, referencing the specific regulations that are not being met and outlining the steps required for compliance. Fourth, maintain a consistent and impartial application of the rules, ensuring public safety and upholding the integrity of the permitting process. Question 19. Benchmark analysis indicates that a client in Sao Paulo, Brazil, who holds a valid Porte de Arma de Fogo, discovers that their permit is due to expire in 2 weeks. They have initiated the renewal process, but are concerned that the renewal might not be completed before the expiration date. What is the most prudent course of action to ensure compliance with Brazilian firearm regulations? Option A. Advise the client that they can continue carrying the firearm while the renewal application is pending, as the act of applying for renewal implicitly extends their authorization. Option B. Advise the client to store the firearm securely and wait for the renewal to be completed before carrying it again, without explicitly instructing them to stop carrying immediately. Option C. Advise the client to wait until the permit expires and then apply for renewal, assuming that a short lapse in validity will not be considered a serious offense. Option D. Advise the client to immediately cease carrying the firearm and diligently pursue the renewal process, understanding that carrying is only legal with a currently valid permit. Correct answer is D. Advise the client to immediately cease carrying the firearm and diligently pursue the renewal process, understanding that carrying is only legal with a currently valid permit. Explanation. Scenario analysis. This scenario is professionally challenging because it requires navigating the nuanced legal landscape of firearm possession in Brazil, specifically concerning the validity and renewal of a Porte de Arma de Fogo. The applicant's situation, involving a potential lapse in documentation due to unforeseen circumstances, necessitates a thorough understanding of the legal requirements and the procedural steps for compliance to avoid illegal possession. Misinterpreting the renewal window or the implications of a lapsed permit can lead to severe legal consequences. Correct approach analysis. The best professional approach involves advising the client to immediately cease carrying the firearm and to initiate the renewal process for their Porte de Arma de Fogo, understanding that a lapsed permit means they are no longer legally authorized to carry. This approach prioritizes strict adherence to Brazilian law, specifically the Estatuto do Desarmamento, Disarmament Statute Law No. 10-826/2003, and its subsequent regulations. The law clearly stipulates that carrying a firearm without a valid permit constitutes a crime. Therefore, the immediate cessation of carrying and prompt initiation of the renewal process, even if the permit has technically expired, is the only legally sound course of action to rectify the situation and avoid further legal jeopardy. This aligns with the ethical obligation to provide advice that ensures compliance with all applicable laws. Incorrect approaches analysis. One incorrect approach is to advise the client that they can continue carrying the firearm while the renewal process is underway, assuming that the application for renewal implicitly extends their previous authorization. This is legally flawed because Brazilian law does not provide for an automatic extension of carrying rights based solely on a renewal application. The permit must be actively valid. Continuing to carry under these circumstances would expose the client to charges of illegal firearm possession. Another incorrect approach is to suggest that the client simply wait for the renewal to be processed without taking any immediate action, especially if the lapse is recent. This overlooks the fact that the moment the permit expires, the legal authorization to carry ceases. Delaying the renewal process, even if unintentional, means prolonged illegal possession. Furthermore, depending on the specific circumstances and the interpretation of the law by enforcement, a significant delay in renewal could also impact the eligibility for renewal itself, potentially requiring a new application process. A further incorrect approach is to advise the client to store the firearm securely and wait for the renewal to be completed before attempting to carry it again, but without explicitly advising them to cease carrying immediately. While storing the firearm is a responsible step, the critical failure here is not emphasizing the immediate cessation of carrying. The legal prohibition is on carrying without a valid permit, not just on improper storage. This approach fails to address the immediate legal risk of carrying. Professional reasoning. Professionals advising clients on firearm permits in Brazil must adopt a risk-averse and legally compliant strategy. The decision-making process should begin with a clear understanding of the current legal status of the client's permit. If the permit is expired or about to expire, the immediate priority is to prevent any violation of the Estatuto do Desarmamento. This involves advising the client to cease carrying the firearm immediately. Subsequently, the focus shifts to guiding the client through the correct procedural steps for renewal, emphasizing the importance of timely action and understanding that carrying is only permissible with a currently valid permit. This layered approach ensures both immediate legal safety and long-term compliance. Question 20. The assessment process reveals that a Brazilian citizen's Porte de Arma de Fogo permit expired 3 years ago. The annual renewal fee for such a permit is $250. If the citizen wishes to renew their permit, what is the minimum amount they must pay to cover the renewal fees for the entire period of expiration, assuming no additional penalties or interest are applied beyond the standard annual fee for each lapsed year? Option A, $750. Option B, $250. Option C, $1,000. Option D, $500. The correct answer is A, $750. Explanation. The assessment process reveals a scenario that is professionally challenging due to the nuanced interpretation of firearm possession regulations in Brazil, specifically concerning the validity period of permits and the associated renewal fees. Applicants must demonstrate a clear understanding of the legal framework governing firearm ownership, including the financial obligations tied to maintaining permit validity. Careful judgment is required to ensure compliance with the Polícia Federal's directives and to avoid potential legal repercussions for expired permits or unpaid fees. The best professional approach involves accurately calculating the total renewal fee based on the established annual fee and the number of years the permit has been expired, ensuring the payment covers the full period of delinquency. This approach is correct because it directly adheres to the legal requirements for permit renewal in Brazil, as stipulated by the Polícia Federal. The law mandates that all outstanding renewal fees must be settled to reinstate a permit. By calculating the total amount due, including any accrued penalties or interest, if applicable under Brazilian law, though for simplicity in this question, we assume a direct annual fee calculation, the applicant ensures full compliance and avoids the risk of their application being rejected or their firearm being considered illegally possessed. This proactive and accurate financial settlement demonstrates responsibility and respect for the legal process. An incorrect approach involves calculating the renewal fee based solely on the current year's fee, disregarding the period of expiration. This is professionally unacceptable because it fails to meet the legal obligation to pay for the entire duration the permit was inactive. Such an oversight would lead to an incomplete payment, rendering the renewal application invalid and potentially resulting in fines or confiscation of the firearm. Another incorrect approach is to assume that a grace period exists for fee payment after the permit's expiration, and thus only paying the current year's fee with the intention of settling the arrears later. This is professionally unacceptable, as Brazilian firearm regulations do not typically offer such grace periods for fee payment without penalty. Relying on an assumed grace period is a misinterpretation of the law and exposes the applicant to legal risks. A further incorrect approach involves attempting to renew the permit without paying any renewal fees, believing that the initial permit issuance fee covers perpetual ownership. This is professionally unacceptable, as firearm permits in Brazil are subject to periodic renewal with associated fees, as mandated by law. The initial issuance fee does not grant indefinite ownership rights without ongoing compliance with renewal requirements. The professional reasoning framework for such situations should involve 1. Thoroughly understanding the specific legal requirements for firearm permit renewal in Brazil, including fee structures and payment deadlines. 2. Consulting official documentation from the Polícia Federal for precise details on renewal procedures and costs. 3. Performing accurate financial calculations to determine the total amount due, accounting for the full period of permit expiration. 4. Ensuring all required payments are made promptly and in full before submitting the renewal application. 5. Seeking clarification from official sources if any aspect of the renewal process is unclear.